Okay, we're live. Good evening. Good evening to all of you. I hope you had a wonderful, wonderful Wednesday. To those of you on replay crew, whether you're watching in the morning, afternoon, or whatever day it is that you are watching, welcome. And I hope that you all are having a great time as well. Love the replay crew. So today we're going to continue our recap and coverage of the case of Kowalski versus Johns Hopkins All Children's Hospital. This is a case that was documented in the Netflix documentary Take Care of Maya, involving a minor child that was treated for CRPS, complex regional pain syndrome, back in 2016 at Johns Hopkins All Children's Hospital. Various allegations of conduct by the hospital that was not conforming to standards. So it's a medical malpractice case, but the issues in here are very sensitive in nature, especially because at the conclusion of the factual scenario, laying the underpinning for the claim is the taking the life, Beata Kowalski, Maya Kowalski's mother, taking her own life. So in light of the sensitive topics that we do discuss on this, I do roll a banner when I'm running a discussion on this particular topic, just so that we're aware that there are some sensitive issues being discussed. I appreciate the chat and the dialogue and the respect that is shown to the various chatters as we break down this case. It's a really complex case. For those of you wondering why I'm covering it, I'm a domestic relations practitioner. I've practiced in the area of domestic relations litigation for over a decade, and this case is an intersection of domestic relations litigation, family law, and then personal injury claims. So I'm very fascinated by some of the allegations here. There's a lot of interplay between Department of Children and Families orders and dependency court orders, and how the hospital was or was not complying with those orders when they were sheltering Maya, and actions taken before the shelter order was entered. So today is day 9 of the trial. And today we had testimony by 3 individuals. Mark Zimmermann was the attorney that was hired by the Kowalskis to represent Maya in the dependency action. He testified remotely. That'll be fun to hear. Then we had Dr. Cantu. This was the doctor in Mexico that placed Maya under the ketamine-induced coma. That was the outside of the U.S. treatment that the Kowalskis had engaged in. And then finally, we had testimony from a Dr. Henschke. And that's the doctor that's testifying largely to the injuries that Maya now suffers from, and the cause of those injuries, attributing those to Johns Hopkins All Children's Hospital, because, of course, it's the plaintiff's case. That's a reminder. This is the plaintiff's case. You guys are going to hear me talk about different pieces of evidence that I think is strong. I have been very clear. I am covering this case as neutrally as possible. My job here is to explain what's going on in this case, to explain why the arguments are being made, whether the arguments are or not, should or should not have merit. Some of the behind the scenes, there's a lot of motions practice in this trial, and a lot of people are very confused. A lot of people have opinions on the judge. I like the judge. I think the judge has been very fair. People have opinions on the lawyers. I don't really have issues with the lawyers. I know that they don't do the things that we want them to do all the time, but they're lawyers. And we'll hear from several of them today. I don't really have too much in the way of testimony that we're going to cover, except for Mr. Zimmermann, because I think this was one of the strongest witnesses that we had heard from the plaintiff's case so far. I want to just check in. I put a poll in the chat, and I'm going to give you guys a few more minutes to take a look at that. Running a few minutes behind. Meantime, who was today's strongest witness? And I gave you 3 options. Mark Zimmermann, who was the counsel for the child, Dr. Cantu, and Dr. Henschke. So I'll give you guys a few more minutes to vote in that one. And then I'll give you my opinion. So we're not going to listen to too much of Dr. Cantu's testimony, just because it is through translation, and that is very challenging for everyone to be involved. And of course, we have our favorite thing about this trial, which is the questions from the third lawyer in the room, the jury. Those questions are remarkably insightful into how the jury is perceiving the testimony by the witnesses. And I think that the questions kind of, it gives you an idea of the information the jury wants to hear. Let's go ahead and get rolling with some of those comments. Make sure that I'm not missing anything. We do want to get some of these early super chats just so that they're out of the way and they're not being brought up out of context. Matt, hello, my friend. Good day. Spiffy, legal mumbo jumbo, talkie brother from another brother. Same thing you said yesterday, and I loved it yesterday. I love it today. Nikki Lewis, thank you. It appears Anderson had a personal matter come up. We'll mention that. And I might give a little insight. I don't know what that matter was, but I have a personal experience similar fashion that made me think of today, that they kind of had me for a couple of minutes. Chilla, new member. Chantal, new member. Amy Miller, thank you, Rob. Super appreciate the recaps. Thank you, Amy. Seaberg, thank you for the super chat. For the kids, really enjoy these recaps. Thanks, Rob, for your info. Thank you. Ryan YYC. Hey, Rob, looking forward to some splaining tonight. I am too. Laura Leanne, hey, all new peeps coming from Recovery Addict. Recovery Addict has been covering this case. I haven't taken a look at it, but I know that there has been some coverage on this case in that channel. So for those of you interested, you are free to check that out. I also want to call out some gifted memberships that were already brought in. Ryan YYC gifted 5, and Fiona gifted 10 memberships. So you guys are, if you see your name go green, you've been gifted a membership to the channel. I do some behind the scenes stuff from my workshop, because for those of you who don't know, I'm also a woodworker. I'm a full-time practicing lawyer, a woodworker, and a part-time YouTuber. So I don't have a lot of time, not a lot of free time, which explains why sometimes a little bit late. So let's go ahead and get into it now. I've been gaining up the volume on the court feed because it's relatively quiet. And we are going to start not with the motions arguments, because there wasn't too much that went there today in the morning session, just a lot of stuff over redaction. But let's go ahead and start with the testimony of Mark Zimmermann. Let me see, share the screen. The volume on the court feed is gained up, so I can't fix that. I can't change that. Closed captioning is off on today's feed from Tampa 13, the Fox affiliate in Tampa, who's been covering the trial. And let's see, share the screen. There we go. Let's go ahead and see what Mr. Zimmermann has to say.
Since you were last with us, have you seen any media accounts of this case? Thank you very much. Now, members of the jury, our next witness is going to be by Zoom. Oh, and okay. There you go. Mr. Reyes has put it up on the screen, so you should be able to see Mr. Zimmermann.
I do speed this up to 1.5 times so we can get through the testimony.
And members of the jury, just like with the last witness who testified via Zoom, I have already sworn Mr. Zimmermann to give his testimony under oath. So he is already under oath. Mr. Anderson.
Hey, please, court. Good morning.
Good morning.
I don't think we met up, Greg Anderson. And your name is, for the record?
Marcus Zimmermann.
Where do you live, Mr. Zimmermann?
Sarasota, Florida.
And where are we talking to you from?
Just outside. We just left port in Olympia, Greece.
Sounds nice. And are you an attorney licensed to practice law in the state of Florida?
Yes, I have been since 1991.
And was there a time that you were counsel to Maya Kowalski in a shelter proceeding?
Yes, in a dependency proceeding.
The dependency proceeding. Right. And although I don't think we need to go into great detail, can you give the jury a bit of your background, training, and experience and history up to this point in your practice?
Sure. I graduated from Cornell University undergrad, University of Florida for law school. I was an assistant state attorney in Sarasota County from 1991 until late 2000. And then I went into private practice. I've been a private practice attorney in Sarasota County from 2000 on to this point. My practice is primarily criminal law and matters related to criminal law. So I do handle dependency cases where there is something allegedly criminal related to this case. And in the Kowalski matter, my client was the alleged victim of a criminal act, not as part of a criminal proceeding, but as part of a dependency proceeding. And that fit the definition of my practice.
Very good. Can you tell us how then you got involved in this case?
I was contacted by, I believe it was Verena Van Ness. We were assistant state's attorneys together. We've known each other a long time since, in fact, we started the state attorney's office around the same time. Ms. Van Ness represented Beata Kowalski, my client's mother. I also knew very well Deborah Salisbury, who represented Mr. Jack Kowalski. And there was already an attorney appointed to represent Maya, but they felt that would be helpful to bring me on as private counsel to Maya.
I have it. And as private counsel to Maya, can you explain to the jury where your, self-explanatory, but your duties and responsibilities with her specifically as private counsel?
Yeah, so that was actually a very big part of my becoming her counsel. I had to make it very clear to everybody involved, including Ms. Van Ness, Ms. Salisbury, and Jack and Beata Kowalski, that my duties were to Maya. I was her attorney. Her legal needs were my focus. Obviously, there was some overlap quite a bit between in the goals of the various parties, but my loyalties and my duties were specifically to Maya, and everybody understood that that's the way it was going to be. I wouldn't be her attorney unless that was clearly understood.
Okay, this is our first little pause moment. I'm not going to pause too much during Mr. Zimmerman's testimony because I think it's pretty important that we hear it. But I did want to give kind of the explanation here. So in the dependency case, a dependency action is basically initiated by the state. It is where the state takes on a child dependent and makes them its ward. It takes protective action. It removes the child from what they perceive to be a situation the child is placed in either abuse, neglect, or abandonment. The state takes control. The state issues orders. The court issues an order that governs contact. There's a plan placed into effect about the parents reunifying, and in incident to those proceedings, there are various things that have to take place. It's a quasi-criminal action. So the defendants, the parents, are entitled to legal representation in that case because they're being deprived of a fundamental right, that being their parentage. They're entitled to legal representation. Second, the child is entitled to legal representation. They are usually appointed, well, they are always appointed, a guardian ad litem. A guardian ad litem is an attorney that is appointed by the court to represent the best interest of the child. It is also the case in some instances where the child will have a separate attorney that is hired by the parents. And this part that Mr. Zimmermann makes clear is the role that he lays out. Attorneys are very, very, very strictly bound in both confidentiality, zealous advocacy, and very strict ethical requirements that we have to lay the framework out for whom we represent. And when the interests of the person that we represent collide with third parties, even when they're paying our bills, the interests of the client must supersede those of anybody else, period. You lay that out, you make it very clear. I will have cases where parents will pay the money for the attorney's fees, but I make it very clear that my receipt of those funds means absolutely nothing to my representation. I will not give them information. I will not relay information that is kept secret between me and my client. They don't get to dictate how I try my case. My case is that case that I have with me and my client. Mr. Zimmermann had this conversation. This is the context here so that you guys understand why there might be two attorneys and Mr. Zimmermann's role. He laid out the scope of his role. And then he faced some hurdles. So let's go ahead. Oh, no, not that one. It's this one. That's the one I want. Keep going.
For the purposes of these proceedings, we are waiving the attorney-client privilege on behalf of Maya Kowalski so that you may discuss the matter. How did you get to know Maya? Can you tell the jury a little bit about that?
Well, obviously, before I met Maya, I very quickly familiarized myself with the case. The case had already been in existence for a period of time before I came on board. The shelter action had already occurred, and Maya was already, of course, was at All Children's. So the first thing I did was familiarize myself with the case. I did, of course, confer with Ms. Van Ness and Ms. Salisbury. I also did briefly confer with Maya's parents. So I did get some background. And then obviously I went to All Children's Hospital to meet my client. I think I spoke with her on the phone once or twice before I met her, and she very, very much wanted to meet me in person. She wanted me at the hospital, so of course I went and saw her.
And then how many times would you say overall you saw her, directly or indirectly?
I specifically recall going to the hospital 2 times. It is conceivably possible that I went a 3rd time, but it's been a long time. I do specifically recall two distinct visits. And then of course she eventually was permitted to come to court one day. I think it was January 6th in 2017. And then I met with her that day in court.
So you represented her in court as well?
I did. I correct. I mean, there were many times, or several times, where I represented her in court and she was not present.
Got it. All right. So tell the jury, if you recall, when you first arrived at the hospital to meet your client, your general impression of the room, her, and the situation.
I first met her outside of her room. She was brought out to meet me in a waiting area. She was in a wheelchair. I remember she was in a dress. And yeah, I met with her in that was my first meeting with her. It was in that hallway in the wheelchair.
Well,
is anyone already feeling weird about this? Like, is anyone already feeling weird about this? He's going to meet his client. We're not allowing him in the room. I just felt odd. I felt odd. I don't know if it's within the confines of the order, and the jury's very curious about that as well. This was a weird start.
That sounds like a rather public place. Were you allowed any privacy in that sense?
Not immediately. That was part of an ongoing conversation. Of course, I did have some private conversations with hospital staff, and I did express that I needed to speak with her privately. And there was some people left the room and conferred, and ultimately I was allowed to go into her room with her, and I was allowed to talk to her with the door open.
And so, attorney-client, can you tell the jury about the importance of the attorney-client privilege and the necessity of privacy, and if I may use the term secrecy, from all outsiders?
Yeah, I mean, obviously, we're entitled to speak privately. She's my client, despite the fact that she was 10 years old. And I will say she was very mature for her age. Sometimes I've represented children before, they're just not able to express even their own desires. Maya was very clear what she wanted. And one of the things she wanted was to speak to me in private. I found that very interesting. So, I had been made aware that there was some,
Your Honor,
let's put it mildly,
objection.
Okay, hold on a second, Mr. Zimmerman.
First of all, it's outside the scope of the question. It's way
Exceeds
past the
scope of
question,
question.
was what's the importance of the privacy? He's starting to talk about what he was made aware of, and I don't know where that's going. And secondly, this conversation is not relevant to the claims in the case.
Well, I'm going to overrule the relevance, but Mr. Zimmerman, I am going to ask you to wait for a question, and let's try to confine ourselves to the actual question asked if possible.
certainly.
So the attorney-client privilege is very important, and from your statement, privacy is important. Now, I want you to explain to the jury the issues, the problems that arose with you having confidential conversations with your client.
Objection.
Well,
relevant.
again,
Overruled. You can answer that one.
yeah, I represented her. So my client expressed to me her desire to speak with me privately. I was given the opportunity to speak with her very close to privately. I kept my voice down. So arguably the conversation was private. I was aware that there was someone outside the door who might be trying to listen, but to the degree that it was possible, Maya and I did have a private conversation ultimately in the room.
What was her concern? When you were in private with her, what were her concerns that necessitated, in her view, the need to speak with you alone and be on this topic?
Well, in that meeting, the first meeting, she just wanted, there's
Objection,
something she
Your Honor,
wanted.
hearsay.
Can you give me
It's
any
hearsay.
information, Mr. Anderson? Because it is a hearsay statement.
It's hearsay,
It's a conversation
but he gets around it. The judge just lets it in.
minor in this situation. And again, I would ask the court to consider 80323. And also under these circumstances, this is, although not directly to a medical
Just be little
personnel,
more specific with-
803.4, and as well as, although not directly to a doctor, statement for the purpose of then existing medical, psychological, other interests.
It's not subject to those. The judge lets it go.
I'm going to overrule the objection as to this question. Mr. Zimmerman, you may answer this question.
Right. So I didn't know what she wanted to tell me privately until she told me. And what she told me was that she didn't want to be in the hospital. She told me that she was in a lot of pain, and that she wanted to go home to see her parents. That was her primary focus.
Did she say anything about, at that time, her relationship with the personnel that were taking care of her, for lack of a better term?
Same objection, Your Honor.
Same response.
Overruled.
There was a social worker at the hospital that was assigned to her case, and I met with that social worker, and Maya expressed a specific. I'm trying to choose between whether it was a dislike or a distrust, or probably both, for that person. I think she blamed that person specifically for keeping her away from her parents.
And so as time went on then, did you observe, and strike that, what was that social worker's name? Kathy Beatty?
Yeah, Kathy Beatty.
And so as time went on, can you tell me whether there were, from what you saw and what was expressed by Maya, further concerns with this social worker's behavior towards your client? And that's in lead up to what you did.
Sure. What Maya expressed was that the social worker was keeping her from being able to speak freely to her families, particularly her mother and father. I think she felt that the social worker was keeping her from talking openly and freely with myself.
Did she feel like,
So
did she seem like she was
specifically, that was the biggest issue.
did she seem as though she was in any way fearful, either fearful or uncertain, approaching fearful about consequences when she tried to speak openly to you or her family?
I'm not sure if consequences is the word I would use. I would say that it was more of the nature of she was being prevented. And, to be fair, I would honestly say that the best way to describe how it affected Maya was that she seemed miserable to me. Remember, I'd never met this child before in person, so I wasn't exactly sure what I was going to be presented with. And I'm not easily surprised in my practice, but I didn't know what I was going to encounter at the hospital. But it left me a little bit shaken and very surprised as to why a hospital employee would have such an interest in limiting this child's ability to communicate with her lawyer and family. I really didn't understand what I was encountering. So I was kind of trying to put all the pieces together. And obviously I was getting some information from Maya, but remember, she was 10 years old. But she was very clear in that the hospital personnel, or specifically this one social worker, was limiting her freedom, I guess is the best way I could put it. She felt captive.
And so did there come a time you saw Maya again?
Yeah, I came to the hospital a second time to see her.
Had anything occurred between the first and second time, or are we picking up with the next chance to evaluate Maya?
Yeah, it was the next chance to evaluate her. I sort of waited till I got a sense that the misery level was hitting sort of, a high point. So I know that both of my visits came at a time when I felt that there was a sense of urgency. My client was expressing urgency to see me.
And what were your concerns based on what she was telling you or you were being told about her situation? And I'm directing you more towards her mental health and physical health.
Right. So she was extremely consistent in her expressions about her physical health. She would identify her pain as a 10. So I know that this was a child. She seemed to be, well, because of her condition, she's sort of used to being in pain, but she was expressing to me a lot of pain. As far as her emotional well-being, it was deteriorating, I guess is the best way I could describe it. I have children. I know what a child in distress seems like. So this child was sort of emotionally withering. She loved her family and her parents. She was kept away from them. I mean, if people can imagine what it's like for a 10-year-old child to be kept from her parents by people she doesn't trust, it's not an easy thing to put into words.
Did you find Maya to be mature enough to state to you, from based on your conversations and what you had learned about her, did she appear to be mature enough, even at 10, to adequately express or clearly express what was going on to her?
I remember telling people, like my law partner, who's also my wife, that she almost seemed that she had the affect of a much older person, almost a person in her 20s, and her ability to articulate her feelings. So yes, she was very clear to me. I mean, and very redundant. I mean, she was repeating the same things over to me a lot. I mean, I had to tell her that I was in fact hearing her because she kept repeating herself. I wanted to let her know that I was hearing her, but it was a constant statement of, I miss my parents. I want to go home. I'm being prevented from seeing them. I'm in pain. She wanted me to know that she didn't think that what the hospital was doing was helping her, which I thought, I found that surprising, but I shouldn't have, because quite frankly, she had this chronic condition and she'd been getting medical treatment for quite a bit. So she did have a strong sense of what her medical condition was and what her well-being was, what her treatment regimen or normal treatment regimen was.
So the times that you saw Maya, was Miss Beatty there both times?
That is something I'm having a hard time remembering. I also spoke with Ms. Beatty on the phone multiple times.
And what did she express to you? Let me stop you for just a moment. On either any of those phone calls, or if you recall meeting her in person, did Miss Beatty ever acknowledge that the relationship with Maya was not good, or words that?
Yeah. Ms. Beatty was very preoccupied with the rules, or what she perceived to be the rules related to who could have contact with her. She was very.
And here we start to get into the point. So Ms. Beatty is the social worker hired by the hospital. Ms. Beatty's deposition is going to be played, I believe, tomorrow. I've been very curious to hear what that deposition is like. Ms. Beatty, from all the evidence we have so far, took the orders, viewed them as being the bottom line rung of what she could impose, and then imposed things in excess of that, things different than that. And it was interesting to hear Mr. Zimmermann talk about this, because I mean, people are going to have a different understanding of Mr. Zimmermann. They might find him credible, not credible. It's up to you. I didn't see anything wrong with his testimony. I didn't really see any red flags that would say, yeah, it kind of seems shady. No, what he was saying here is that Ms. Beatty took the orders, interpreted them how she saw that they should be interpreted, and then imposed rules on contact with Maya. She became, I guess, the warden of the prison. If you're talking about access to clients, people have asked questions about privacy and communication with lawyers. If I go visit a client in the jail, they bring my client out. They bring him or her to the room. I get to talk with them. Period. That communication, that conversation is private. No one's listening in. Nothing. It doesn't matter. It doesn't matter if my client is a female client, a male client. If I'm in that communication, if I'm in that room with my client, that communication is confidential. You can't come in and tune in on it. You can't double check to make sure I'm not saying something that mom told me to relay. You can't come in there and check that I'm not giving her something that mom told me to give her. You can't do that. And from my understanding, we're going to get into the orders in a little bit, but this is really fascinating to me. And someone was asking how why the parents hired the attorney. A guardian ad litem is appointed by the court. There's a select number of them. It's a pool of them who volunteer to do the service. And I say volunteer, they get paid reduced rates by either the parties to whom they're appointed or the state. And think of it like a public defender. You don't know what you're going to get. You can get a good one, you get a bad one, you get a mediocre one, you get a tired one, you get an active one, you can get one that has a caseload that's massive. You don't know what you're going to get. So I take no issue with the parents in this case hiring a lawyer for their daughter, because this is a complex case. I don't know that I would trust a GAL to really get caught up to speed on every single part of this. So we shall see. Yeah, Kathy Beatty was fired. She was fired. She's no longer with the hospital, but she was employed at this time. That's the relevant part.
I would say overly interested in making sure that those rules were strictly enforced. I mean, I was trying to ascertain what her agenda might have been. Perhaps
Your Honor, object to opinions with respect to somebody's quote agenda and quote and outside the scope of the question.
I like Plaintiff.
Overruled. You can finish, Mr. Zimmerman.
Yeah, I mean, I felt it was my duty as my client's attorney to understand what forces were affecting her. So I did. It was very odd that this social worker, who I thought her interest should be my client's well-being, seemed honestly preoccupied with, who was allowed to see her under what circumstances. I found that very, very odd. I just wanted to see my client.
Was the term micromanage a term you would use, and with Miss Beatty's interests in who Maya saw and when she saw them and how she saw them?
Yeah, I mean, I would say agenda driven. I mean, I felt that she was trying to accomplish something, and what it seemed to me that she was trying to accomplish was to keep my client isolated. Now, why that was, I didn't know, but that was clearly her goal, to isolate this child from her family and her lawyer.
Now, how long, if you can give the jury an idea, the time period we're talking about here, from your first introduction to Maya until the end of your representation, where are we in that late 2016, early 2017 period?
I think I saw her in the first time in early December 2016, and I think the second time I saw her was maybe 10 days to 2 weeks later. That feels about right to me. It was over the course of about 3 weeks, and then shortly thereafter, seeing her in court, and that was the last time I saw her, I think, until the funeral.
The record reflects there was a court hearing on January 7th of 2017, immediately before Maya Kowalski's death.
Excuse me, I believe, counsel, it's January 6th.
January 6th.
I'm sorry, the 6th was the 7th.
Yeah, that was January 6th.
I apologize. That was that Friday. All right. So the second time you saw her, was this situation getting better or worse in terms of Maya's relationship with this hospital staff, particularly Ms. Beatty?
Oh, worse. That was easy. It was growing from frustration to desperation. That's the best way I could phrase it. I mean, remember, you have to remember, this is a 10-year-old, even a mature 10-year-old. She was fraying, and I was worried, but I knew that I had to express to her that I could only do things for her in court, so that, she wanted me to do things immediately. Like, she wanted me to talk to people and make things happen at the hospital. I was honest with her. Even though she was 10, I treated her like my adult clients. I was honest with her face to face and explained to her, I'm only going to be able to help her when I go back to court and see the judge.
Now, in the second visit, were you required still to have the door open during your consultation with your client?
Oh, yes.
And
yeah, there was a real reluctance, like a mistrust of me. These people didn't know me.
did they know you
there to represent my client?
Well, did they know you were her attorney?
Oh, yeah. Oh, no, I made it very clear. I will tell you that I went there to make nice to these people, and to put it that way. I didn't go in there with any kind of bluster. I didn't try to intimidate and throw my weight around. I used the exact opposite tact. I tried to be as nice as I could and let them know that I'm just there to help my client and not cause anybody any trouble. I was obviously aware that there was quite a bit of, acrimony going on between the family and the hospital, and I thought it best to try to play peacemaker in my ability to just help my client and have access to her.
Now, in addition to Ms. Beatty, how would you describe your reception by the others that you dealt with in the hospital once they knew that you were Maya's attorney? Warm, cold, indifferent?
I felt like there was a certain, an amount of suspicion. I mean, I think that, and I didn't know why, obviously, because I was not dealing with mom and dad's interactions with the hospital, but I certainly had the sense that those were not going well. And I felt that, I was being treated as though I was part and parcel of whatever was going on behind the scenes. I wasn't, but that's how I was being treated.
Now, did they put forth a reason why it was so necessary for them to stand outside the door with the door open during your consultation with your client? They talk about the child being unsafe or some disease or something. I don't know.
Hold on a second. Mr. Zimmerman.
Objection to, there's no evidence that somebody was standing outside the door, just that the door was
He
open.
did.
Sorry. Let's just go to this Dr. Mason. Sustain the objection. You can re-ask your question.
On this opportunity to see your client, you testified the door was open. Tell the jury, if you did believe, how and why you believe that somebody was outside that door, either listening or just standing.
Wait, you want to know how I knew that someone was out there?
Yes.
It was made clear to me that someone was going to be out there. You know,
Could you
as
hear
though
them?
I was going to do something, as though I was going to do something wrong in the room. I don't mean physically harm my client, but that I was going to violate some kind of, I don't know what it was. Maybe like that I was going to express something about her treatment or something like that. But obviously, I had no intention of doing anything like that.
So from what the hospital was telling you, they wanted to listen into your conversations to see if you were following their rules.
Leading.
Yeah,
Leading.
they
Sustained.
What, if anything, were
Yeah.
your witness what they were trying to do?
they
Still
were-
leading.
it was clear to me that they were acting under what they thought to be some type of authority. Now, whether it was something they were getting from the hospital administration or whether it was something, their interpretation of a court order, they were acting as though they were, you know, how can I put it? Well, you know, I mean, I don't know exactly.
It's all right.
You know what I mean? I mean, to be quite frank, I mean, I only can say that they didn't trust me. You know what I mean? And that they felt it was their duty to monitor me.
Even,
I can't say where they perceived their duty came from. That I'd be speculating on.
even knowing that you were her attorney, they did this?
You know, everyone knew I was her attorney. That I made crystal clear.
So did they ever express any incident or accident, some reason why they felt, outside of what we were talking about with just being enforcers, or however you put it, but did they reference any specific event or accident or thing that necessitated this? Did they discuss with you anything about Maya falling?
No, I mean, yes, that was specifically discussed. There was a time where Maya, I think she was reaching for a phone, and there was a concern that she'd fallen, and they were expressing that, you know, that there could be some type of a safety issue. But I mean, again, I was just talking to her in a room.
Okay, so we're going to pause here for a minute. I'm going to fast forward because we're not going to listen to all of his testimony, but I want to answer some questions. Are you kidding me? There's someone standing outside the door because they're worried about a safety issue when he's in there and he can call someone to come to the attention. It's not why they were there. And his perception, and I want to also note that defense counsel chose this attorney to cross-examine this witness. You don't hear a lot of objections. I mean, you do, but not really. There's a ton of objectionable testimony, speculation. He's giving his impression on what they were thinking, I mean, he is giving his impression. And the reason why the attorney is not objecting is when you have an attorney on the stand, it's a dangerous game you are playing. If you start objecting, that attorney's going to start finding words to work around it. That attorney knows what they need to say and can say. So you don't want to really just start objecting left, right, and center. Plus, because what this guy could say could be a whole lot worse. I mean, he's speculating a bunch. He's giving his impressions of what the hospital was doing. I don't doubt the speculation is accurate. I don't know. But it would be worse if the attorney starts objecting left, right, and center and giving this guy an opportunity to expound even further. This is a very harmful witness for the plaintiff or for the defendants. Very, very harmful witness. Because what he is illustrating here is that there may have been orders in place, but the conduct of observing, of all this other stuff was outside the bounds of what he had perceived the orders as authorizing. You were to make the comment about, I don't know what authority they were operating under. This is someone who's read the orders. So he's doing well. Doesn't go too far into details. It was interesting. And for those of you wondering whether he's bringing information back to the parents, if he is, then that's his bar license. I don't think he is. Someone was also asking a question, so he made the comment. So he shared what he had discussed with his law partner, or with his law partners and his wife. What you missed is that the wife is the law partner, and law partners are under that umbrella of confidentiality. So my law partner is allowed to know the inner details of my case because she might have to step in and represent. My entire firm represents that client. So that's allowed to be discussed. And then another clarification, Laura Liani, aren't neutral court appointed child advocates there? I believe there was a GAL appointed in this case. I don't know. We don't hear a lot from that GAL. I think the GAL probably just wanted nothing to do with it. I'm not really sure. So it's a good question, though. And let me see. Jody Osborne, I did want to bring this question up, where the whole day of testimony is shown. Only find 2 hours on Law and Crime. Law and Crime has been having issues with their stream. When they finish, when they wrap, it's like it goes back and it only shows you the past like 30 minutes or 2 hours. I've been watching on Tampa 13. They break up the morning, the afternoon session. And then if there's motion stuff, sometimes they don't catch that. I go back to Law and Crime and try to catch that. So that's where I've been kind of watching all of this. See if I didn't cover anything else. Creed M. Yep. Interestingly, later in the day, Mr. Anderson blasts the hospital for allowing a male doctor to be alone in the room with her, allowing the alleged behavior to occur. Just an interesting parallel. It is. It is. Not going to go much further than that. I think that doctors are allowed to be in the room with their patients. Attorneys are allowed to be in the room with their client. Jen Selfridge, thank you very much. M2H MGHB. It's something common I've seen with other kids who have chronic illnesses. They're more articulate because they've had to tell doctors what's wrong. Maya seems to have been very smart. There's a lot of comments that are made about her intellect, and the fact that she was wise more than her years would have suggested. So it's been interesting hearing that testimony. Casey Cat, thank you. Thanks, Rob, for helping me understand how the case is going. You know why it's so important to me, and big love to my RSD CRPS cohort Mapon. Yep, I know why it's important, and I'm glad that you're here watching. I find this case important too. And thank you, Killy Kenna 09 for the super chat. Okay, let's go ahead and fast forward to my favorite part, the jury questions. My favorite part of every witness has been the jury questions. I have found them to be the most illustrative of what is going on in that courtroom. Wait a second.
Okay, Mr. Zimmermann, I'm asking you to unmute your microphone.
Hello there.
Can you hear us again now?
I can hear you.
Okay. Members of the jury, I know that there was a request to see the orders. I will tell you, you will be receiving from me in the future a detailed instruction about those orders. If you just give me some time, but it's not happening with this witness, it's not happening today, but I will give you a specific instruction about those orders. Okay, so just hold on that. Now, Mr. Zimmermann, there's several questions from the jury. During your meetings at the hospital, did you observe Miss Beatty listening and observing your meetings with Maya?
On one occasion, she was waiting outside of the room. Obviously, I can't tell what she was doing outside of the room. I could make assumptions, but I was focusing on my client.
Next question from the jury. Did Maya express any religious needs to you during your visits?
Yes, she wanted, I think she wanted to see her priest. And I think she wanted something, to put it, something Christian, a cross, something that she had from her family. I can't remember specifically what it was, but there was some type of I guess I'd call it an artifact that she was requesting. But I told her that I'd pass that information on to somebody, and I'm sure I told a family member, but I never followed up. I mean, I only followed up to the degree that I told her I would. I never saw that to completion.
Did you observe her being provided her religious items?
No. My focus was on what was going on in the courtroom. I was aware of that, but that was not my primary focus.
Okay, can I see the counsel again up here for a moment? I'm going to mute you.
Jury wants the orders. Jury wants the orders. Because the two questions asked by defense counsel in cross was, were they following an order, or did they there was an order in place that restricted conduct? So the jury is now adeptly wanting to navigate this realm and territory of what is the hospital doing? What do the orders allow them to do? And let's go ahead. 1:45:20. Just another few seconds. And we have a relatable moment for me.
And for the other question, at this time, we're not going to be able to address that issue with you. Mr. Anderson, you may continue question.
Mr. Zimmermann, I apologize. I forgot an area up here to ask you. Do you recall there was a suggestion or discussion about a legalized separation of Jack and Maya Kowalski?
Oh, oops.
Help.
I actually didn't unmute. He didn't hear any of it. That's totally my fault, Mr. Zimmerman. We were asking you a question and I forgot to unmute you.
Oh,
That's my fault.
Judge, I know.
I try to be a TV director in my day job as well. It just doesn't work out.
Oh, Judge, I know.
Mr. Zimmerman. I'm Mr. Anderson.
Yeah, I have days like that. Those days like that. Mr. Zimmerman, there was, I had forgotten to ask you a question when I was last up here, and it was about, were you involved in advice on a discussion or suggestion that Jack Kowalski and Maya Kowalski separate, a technical separation for the purposes of being able to get Maya out of there?
I was aware of that discussion, and I did participate in that discussion.
And did you have some advice regarding Kyle Kowalski that ultimately, from your perspective, carried the day?
I mean, I can tell you that I would best describe it as horror at the suggestion that these folks divorce to resolve this matter. That I can tell you. You know, they have another child. It didn't make any sense to me. It made me understand the desperation that this family was under, that they would even contemplate something like that. But my 2 cents, if you will, to the degree that I had any control over anything, was that conversation be shelved and never discussed again. I was very vehemently opposed to it.
And so the jury understands that suggestion did not come from Jack and Maya. That came from one of the counsel.
It did.
Thank you, sir.
Ms. Perales, any follow-up?
No, sir.
And members of the jury, do you have any further questions? I don't see anyone writing, so I think that's a no. Okay, Mr. Zimmerman, at this time, you can continue sailing on to your next port of call. Thank you for being with us.
Your Honor.
Hold on a second.
Tomorrow in Santorini.
Hold on a second, Mr. Zimmerman.
Santorini.
I want to release-
Santorini tomorrow.
I do not believe that I'll need to, but if we are going to come back.
Must be
for a
nice.
document, I'd like to
Okay,
say
okay. So,
that.
Mr. Zimmerman, you're free to continue sailing today, but you might need to be called back. So please don't have any discussions about this case except for with the attorneys.
Absolutely.
Okay,
Understood.
have a good day. You're free to go today.
Thank you, Judge. Take care.
Okay. Members of the jury, we're going to take a morning break at this time. Please do not discuss this case amongst yourselves. Do not do any investigation and receive no information. And let's
We're
try to be
going
back
to
in
leave
about
this
10,
up
15
for
minutes.
a second here.
Can I have up here Mr. Anderson and Mr. Hunter?
So it goes muted, but the camera pans back down. And the judge relays a note to Mr. Anderson, for those of you guys that are watching but can't really see or just listening. And the judge explains the note that he received. Mr. Hunter is up there as well. Mr. Hunter reads the note. And then Mr. Hunter, you can almost see him audibly say, "I'm so sorry," and pats the back of Mr. Anderson. I don't know what this means. I don't know if it would be a personal issue. I don't know if it would be an issue with the witness. But it was a moment in court that transpired, and it stays for a minute. So we don't know what the note is about. There's been no reporting on it. It's been quiet about it. There's no mention of it in court. But it's a human element of these proceedings where these lawyers are going at each other, and they are humans at the end of the day. Like, they really are. And the judge, that judge,
15 minutes.
when you saw the judge does this little gesture, like the back and forth thing with his hands. That's the judge telling Anderson. I'm almost positive this is the only part I'm going to speculate about really solidly. That was the judge telling Mr. Anderson that he can remain facing the bench. He can remain facing the bench so the camera doesn't catch him. Because the judge knows the camera's facing there, and the judge knows the cameras are facing sidebars. It's one of those things where the court does the gesture very clearly, kind of keep facing this way. And Hunter walks away, and Anderson just remains there standing, staring down at the bench. It was, 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 it was So my first thought was that it was family news or something to that effect. I don't know. I don't know what it was. It's hard to think that he would receive family news via the court or the court clerk. I don't know if that's the case. I don't know if it's not the case. I don't know if it's a witness. I don't know what it might be. What I will say is that when I watched this reminded me of an experience that was very close to home. And I don't know if I've talked about this on stream before. In 2019, in June, my dad was, he had been late term cancer, and we'd kind of stopped the treatments because we knew it was going to happen. We knew there was an ultimate day coming, and that he was on the West Coast in Washington State, and I was on the East Coast prepping for trial. I had trial the next week, and I was supposed to fly out after that trial was done. And lo and behold, on June 7th, I get a call from my sister who's out there with him saying, "You need to get out here. I'm prepping for trial." And I've got my trial binders in front of me, and I notify my law partner who's in court on another matter. My law partner calls opposing counsel who was also in court that day, and my law partner and opposing counsel walk into the judge's courtroom where I was supposed to have the trial. And opposing counsel made the motion to continue the trial. Not all lawyers are shady. Opposing counsel made the motion to continue the trial. And actually said, "Judge, for the record, I do believe I have to voice a very soft objection that I know the court's going to overrule because my client has put money up and wants this trial to go forward." But opposing counsel made the motion for the trial to be continued, and the judge granted it. So you can't, I make this comment because we see these lawyers and the judges, and you want to think of them in all these nasty ways. Or good ways. You want to think that they're dumb or they're smart or they make mistakes, it's every now and then it's okay to laugh at it. It really is. It really is okay to laugh at it when they make silly jokes or when they make bad arguments. You can make fun of the arguments, but don't forget that they're people. Don't forget that they're people, and they are working 18-hour days, and they are busting their ass, and it comes at the cost of family time and relationships and their health. So please don't forget that when we watch these trials. So it's tough. Yeah, there's still a dent in my wall from when I threw the binders. Yeah. You never know what they're going through. So when that happened, I immediately thought of that. So my heart goes out to Mr. Anderson for whatever that news was. And you got to snap up and do the job. And he does. He comes back from court and he does the job. So when we're commenting about the lawyers, when you see people in Law and Crimes chat or Tampa 13's chat, or if you see people in the chat and they're going off on a tangent or they're bashing people left, right, and center, just remember that. Like, please, just remember that. I just told you a story that's remarkably personal to me. Just remember that stuff. Dread Pirate Wesley, I love that remark. And it's funny because it makes me laugh. And that's the humor it's a good remedy to it. So humor is a good remedy to a lot of things. And after that, what we end up going is Dr. Cantu. And with Dr. Cantu, I'm going to kind of let him introduce himself. I'm going to give you a recap of kind of his testimony, and then we're going to go to the witness questions or the jury questions. My favorite attorney questions. Make sure if I don't get your super chat, I'm going to try and get to the end of some of the testimony. I'll pull stuff up at the end. If it's a question, I will remember. Nicole, even though they dropped a charge against BD, her actions are still relevant because she was an employee of the hospital, right? Yes. Even though she's not in the lawsuit, I think they dismissed the the case at the very last minute. Her actions are still relevant because she was an employee. Yes. Thank you, Nicole. Jules, thank you for this. Anderson mentioned at the end of the getting out a little early tomorrow to deal with a family from notice earlier. Okay. So maybe it was family news. Maybe someone notified the court. Karen Ricci, can you slow the chat down a bit? I wish that I could. It's on a 60-second delay right now. One of the problems that you guys are going to notice is with all of the gifted memberships, members are immune from me slowing the chat down. I cannot slow the chat down for members. I really wish I could sometimes. And YouTube, if you can fix it, like I promise I won't slow it down to like a minute delay, but let me slow it down. There's a lot of members that are watching because there's a lot of people who gift memberships because they like to give people access to kind of the shop stuff and where I get to talk behind the scenes. I wish I could. Baby Gator, I spent plenty of days in the hospital with my son and had to share my share of misdiagnosis for my pain issues. So the case is triggering yet fascinating. Thank you for covering this. And I try to be respectful of that while I do cover this. It's a sensitive case, and I'm glad that you're here watching. OB nurse Chelsea, the case is fascinating to me as someone who not infrequently has to execute court orders to remove children from custody. It's always hard to navigate and is never crystal clear. Unfortunately, I know. And when you're executing the terms of the order, this case is kind of an example. Don't overextend too much. Like be careful. There's a fine line you got to draw. The order is the guidance. Ashley, I'm not sure why BD isn't testifying live. I imagine unavailable witness. I'm not sure. Maybe they wanted to control the testimony that badly. They didn't want her saying something on the stand, or maybe on the stand she would say something inconsistent. I don't know. But we have the depo. So here we go.
Morning.
Buen día.
Please state your name for the record.
Fernando Cantu Flores.
And where do you live?
¿Dónde estudié? Vivo en Monterrey, México.
And have you flown up here from Monterrey, Mexico to testify in this case as Maya Kowalski's treating physician?
Así fue.
And what are your areas of practice and specialization?
I am an anesthesiologist, and my subspecialty is pain management and pediatric anesthesia.
Doctor, I'd like to may I refer to you then as doctor.
Sure.
Can you give the jury the benefit of your background, training, and experience, including your specializations, towards rendering any opinions here today?
Sure. I started my medical school in Monterrey, Mexico at the Universidad Autónoma de Nuevo León. That's what it is called. And then I finished that. I went to a rural area to do my social service to a little town close by Monterrey in the United States. And after that, I did my training in general surgery. I finished that. I presented my board for general surgery. Then I went to the United States for personal reasons. And meanwhile, I was getting treatment in there. I studied for my boards. I passed my boards, and then I started studying anesthesia there in San Antonio, Texas at UT Health Science Center. Later on, I did my fellowship in pain management, and after that, I did my fellowship in pediatric anesthesia.
So how many years in total were you trained in the United States?
This question is going to keep coming up, so I'll answer it now. Didn't that dude have a translator? Yes. And this is a clarifying point, and it's important to make because this is a trial question people have. When you require the assistance of a translator, the general rule of thumb is that once that translator comes in, you do not answer, even if you understand the question being asked of you, you do not answer that question in English. You answer the question in Spanish or whatever language is being translated so the translator can translate. It's a very formal procedure, and it's really obnoxious for a lot of attorneys because sometimes the client will very clearly understand. They'll be bilingual with struggles in their home language. And you want them to be able to testify in their home language, or you want them to be able to testify, in English if they can understand it. But the rules are pretty strict in this regard. And before they brought Dr. Cantu on the stand, actually, let me pull up the little thing to let me know that he's there. Before they brought Dr. Cantu on the stand, they had an acknowledgement from the from opposing counsel that this was acceptable, that opposing counsel was agreeing to Dr. Cantu answering questions that he understood in English. He could relay in English if he wanted to. It was the medical terms that he wanted to make sure he was being accurate in what he was saying. So it's a challenge. It's difficult, but you kind of have to deal with it. And that was kind of the clarification. If you have a translator, you have to usually ask, you have to answer all questions in Spanish, wait for the translator to translate. And there's an instruction given to the jury that the jury has to take the translated words as the evidence. They cannot take what they perceive to be the Spanish statement or the native language statement as the evidence. It's difficult instruction to give, because I've been examining before, and I've had very bad translators who have translated something in Spanish and it is not a direct translation, or then they go back to the witness and they ask the witness for a clarifying question. I'm like, no, that's not how this works. Nope, not how this works. This interpreter did good though. So yeah. And interpreters are under oath because they have to swear to give accurate translation. Oh no. It's really ham.
There was 1 general surgery, 3 anesthesia, 6 years.
And then you came back to Monterrey, Mexico to begin your practice?
Yes.
And do you practice or have privileges at certain hospitals there?
I do work in every hospital in Monterrey, Mexico.
All right, now, doctor, we wanted to bring you up here and have you explain a little bit about, first, your experience with CRPS, and second, the ketamine infusion treatment that you have perfected for this.
Queríamos traerle para hablar con usted, explicar un poco sobre su experiencia con el síndrome de dolor regional complejo y su infusión de ketamina como tratamiento que usted aplicó en este caso.
Siempre me ha interesado el dolor neuropático propiamente.
I was always been interested in neuropathic pain properly.
Y desde que llegué a mi ciudad, en Monterrey, México, estoy viendo pacientes con el síndrome de CRPS.
And since coming to my city, Monterrey, Mexico, I've been seeing patients with CRPS.
He estado todos los años activo viendo pacientes con el síndrome.
I've been active every year seeing patients with this syndrome.
And about how many CRPS patients have you treated in your career?
¿Cuántos pacientes ha atendido en su carrera usted con CRPS?
Vemos aproximadamente 3 o 4, cuando menos, pacientes mensuales por 12, por 20.
We see approximately 3 to 4 at least patients a month, times 12, times 20.
That's a lot of patients.
Son muchos pacientes.
So were you the treating physician then for Maya Kowalski's medical infusions there?
Fue usted entonces el médico que atendió a Maya Kowalski para su infusión médica.
Así es.
And they're referred to different ways, long-term ketamine infusion, medical coma. How do you refer to them?
Se han referido a ello de varias maneras. Infusión de ketamina a largo plazo, coma médico, ¿cómo lo refiere usted?
Depende de qué es lo que estás intentando realizar.
It depends on what is it that you are trying to perform.
Es el tipo de infusión que vas a dar.
That's the type of infusion you provide.
So could you tell us a little bit about how you became first, the history of ketamine infusions? I'm looking for whether you started it or whether you originated it, or was it already going on when you began doing it?
Quisiera preguntarle un poco sobre la historia de las infusiones de ketamina, si fue usted quien las inició o si ya había comenzado cuando usted las empezó a realizar.
La ketamina es un anestésico que se utiliza con mucha frecuencia.
Ketamine is an anesthetic that is used very frequently.
Se ha utilizado por muchos años desde la Guerra Mundial.
It's been used for many years since World War.
Y se ha utilizado para muchos diferentes tipos de tratamiento, incluyendo el síndrome regional doloroso complejo.
And it's been used for many different types of treatments, including treatment for complex regional pain syndrome.
And so how did the idea of a very long-term infusion come to you?
¿Cómo llegó a usted entonces la idea de una infusión a largo plazo?
Sabemos que muchos pacientes que reciben el tratamiento con infusión de ketamina a corto plazo o en bajas dosis,
We know that many patients who receive a short-term ketamine infusion treatment or lower doses,
ellos mejoran considerablemente, sin embargo, no sostienen su mejoría por largo tiempo.
they improve considerably. However, they do not sustain their improvement in the long term.
And so how does this treatment work as opposed to a series of lesser infusions?
¿Cómo funciona entonces este tratamiento en contraste con una serie de infusiones menores?
Porque tratamos de mantener los niveles séricos de la ketamina dentro del organismo en una forma estable.
¿Los niveles qué?
Los niveles séricos, niveles en sangre
Okay.
de la ketamina en forma continua.
Because we try to keep ketamine levels in blood stable in a continuous manner.
And what effect does that have on the neuropathic ways between the nerves and the brain that may be a cause of the ketamine pain?
¿Qué efectos tiene esto en las vías neuropáticas entre los nervios y el cerebro que pueda ser una manera, o sea, un efecto de la ketamina?
Sí, para entender esto es necesario hablar de cómo nosotros registramos el dolor en nuestro cerebro.
Yes, to understand this, we need to talk about how we register pain in our brain.
Cuando una persona tiene un accidente,
When a person has a certain accident,
puede ser un martillazo, puede ser una herida, puede ser una cirugía, puede ser un esguince.
whether a hitting with a hammer or a wound or a surgery or having a strained joint,
En el sitio donde se produce la lesión hay una inflamación neurogénica.
the area where the lesion is produced, there is a neurogenic inflammation that occurs.
Esto significa que estos mediadores de la inflamación alteran los nervios
This means that these mediators of the inflammation upset the nerves,
y estos nervios van hacia la médula espinal y al cerebro y se unen a receptores.
and these nerves go into the medial cord and the brain and join receptors.
Cuando esto sucede en forma normal, se estimulan los receptores AMPA, así se llaman.
I hate doing this. But I have to. Because this is a recap, I have to skip his testimony. I'm going to give you a recap and a summary of it. So basically, he testifies to what we have already heard about how CRPS works in the neuropathy and how the ketamine is essentially, the concept is this ketamine coma, the coma with the ketamine acts as a reset button. It basically resets all the little synapses so that your brain doesn't feel that pain anymore. And it's supposed to basically give you this, you eliminate the blockage. He testifies that a lot of the conditions that he observed in Maya ended up rectifying after this, that sometimes there's a booster required afterwards. Cross-examination is pretty intense. Cross-examination is intense, but I don't know that he scores a whole lot of points. Because in cross-examination, he talks about how there's the risk of death. And then the doctor kind of fights back and says that there's a risk with everything. And I actually thought about this with the risk of everything and the 50% risk of everything. And I thought about clients that I've had in the past. I've had two clients that have, one client and one family friend who's passed away from anesthesia for a very routine procedure. There's a risk of death with a lot of stuff. And the 50% number is just, that's a number that they put on it. It's not really what it is. It's a very off-ball, it's a very odd procedure. It's a very intense procedure. He was a good witness. He was good at explaining. And I don't know that defense counsel did a whole lot to damage the credibility there. There was a funny moment where he fills his water glass with that little pitcher in front of him, and it basically blows the eardrums off damn near everyone in the courtroom because it's like a waterfall. They go through various photos. They show photos of her in the coma. There's videos that the plaintiff wanted to introduce that they didn't get to introduce that were videos of Beata videotaping when Maya was in the coma. It was really fascinating. I thought it was interesting testimony, and the doctor did push back quite a bit. I did learn that, I learned from the defense cross-examination that Maya, based on defense's assertion, received 55 boosters of ketamine afterwards. And the doctor didn't seem astounded by that number, but he also didn't suggest that was kind of within the realm of what he would have expected. It was good testimony. They show the condition that Maya was in before. They show the condition that Maya was in after. Maya was in a better condition based on the photographs and testimony after than she was before. But then the question comes up, if you did this, the doctor said that, we'll get to this. Let's go to the jury questions, because the jury asked the questions and they're telling us what they want to hear. Right. And there was a bunch of them here. So jury questions were he was on the stand for 2 hours, about 2 hours and 15 minutes. So 2 hours, 15 minutes. $433. Jury questions.
This or any procedure.
Es requisito que todas las casillas
Nope.
queden marcadas.
Checkboxes be met, or during your medical intake.
Dang it. Missed it.
And there's quite a few of them. Okay. Doctor, we have some questions from the jury,
Pero tenemos varias preguntas del jurado.
and there's quite a few of them. Just fine. We're just going to go through one at a time.
Por eso vamos a hablar de cada una de ellas.
It has been mentioned that you have an intake form or system of determining if a patient is eligible for your medical coma treatment.
Se ha mencionado que tiene un formulario de admisión o un sistema para determinar que un paciente es elegible para un tratamiento de coma.
Is it a steadfast requirement that all these checkboxes be met? Or during your medical intake, you as a doctor can ultimately determine the eligibility of the patient for this or any procedure?
Es requisito que todas las casillas queden marcadas o como médico puede usted personalmente determinar la elegibilidad de un paciente para el procedimiento.
Es principalmente la elegibilidad que como médico damos,
It is mainly the eligibility that as a physician we determine,
pero el cuerpo médico del hospital
but the whole medical body of the hospital
y ética del hospital
and the ethical team
lo apruebe.
approves it.
Next question. Is a medical coma used in hospitals for other purposes? And is it a normal and acceptable procedure to use? And this is not a new or strange procedure.
Es el coma.
Your Honor, may I read the question?
Es el coma médico usado en hospitales para otros propósitos y es un procedimiento normal y aceptable en su uso y si no es nuevo o un procedimiento foráneo, extraño.
Es un procedimiento que se utiliza solamente, que lo utilizamos solamente para pacientes con CRPS.
It's a procedure that we use only for patients with CRPS.
Y es un procedimiento que se ha hecho en otras partes anteriormente.
And it's a procedure that has been done in other areas previously.
Is a medical coma a highly controversial and unacceptable procedure?
Es el coma médico un procedimiento altamente controversial y conflictivo, o sea, criticado. Highly controversial and
Unacceptable.
e inaceptable.
Es controversial, probablemente sí.
If it is controversial, probably it is.
No aceptable en términos de qué podemos hablar,
Unacceptable in what terms can be discussed.
porque son pacientes que tienen una pobre calidad de vida
Because these are all patients that have a very poor quality of life,
y son pacientes que muchas veces tienden al suicidio.
and these are patients that in many cases have a tendency to suicide.
¿Qué es? ¿Cuál fue la última palabra? No aceptable. No, yo no pienso que sea algo no aceptable.
Whether it is unacceptable, I don't think it's unacceptable.
Next question. Can you confirm that you said someone with CRPS has a higher tolerance for pain? Is that correct?
¿Puede confirmar que usted dijo que alguien con CRPS tiene una mayor tolerancia al dolor?
No necesariamente.
Not necessarily.
CRPS es uno de los problemas con el más intenso dolor.
CRPS is one of those problems with the most intense pain.
Y son pacientes que tienen que enfrentar el cómo vivir con él.
And these are patients that have to cope with how to live with it.
Well, in follow-up to that question, if you use a pain scale of 1 to 10, what a normal person would describe as a level 10, would that or could that be described by Maya as a level 5 pain?
Oh no, I pulled a judge. Oh no, I pulled judge. I was muted. Dang it. Dang it. Judge Carol, Elaine, microphone. Oh. My statement was hats off to that translator. That question has 19 levels of nuance in it. And to do a fair and accurate translation of that with what is intended to be the question, it's kind of like if I was at a 1, so to speak, perhaps if my feeling was that, and if I had a rating on a scale of 10, if perhaps this person, holy crap, it was, I pulled a judge / Elaine. Dang it.
Como seguimiento a esa pregunta, si se usa la escala de 1 a 10 del rango de dolor, lo que para una persona normal pudiera describir como un 10, pudiera equivaler a un nivel de dolor 5 para Maya.
Sí, porque aprenden a vivir con eso.
Yes, because they learn to live with that.
Ellos pueden hacer sus actividades de cierta forma
They can do their activities somehow
y no aparentar que tienen gran intensidad del dolor.
and not show that they have a great intensity of pain.
In turn, if Maya says her pain level is 10, could that be a level 15 for a It says normal person, a non-CRPS version.
En su lugar, entonces, si Maya dice tener un nivel de dolor de 10, pudiera eso equivaler a un 15 para una persona normal, quiero decir que no padece CRPS.
Es difícil contestar esa respuesta como tal porque es del 0 al 10.
It is difficult giving an answer to that as such because it goes from 0 to 10.
Pero lo que sí puedo decir
But what I can say is
que el nivel de dolor que tiene el CRPS es el de más alto grado.
that the pain level for CRPS is that one of the highest extent.
Que un paciente pueda, porque existen los pacientes que dicen, tengo un dolor cuando uno les pregunta del 0 al 10 cuánto dolor tienes, y ellos dicen 15.
Because there is this patient that you ask them how much pain you have 0 to 10 and they tell you 15.
Quiero asumir que la respuesta anterior a esto, pues es sí.
I want to assume then that the right answer to that is yes.
What was Maya's ASA class when you first evaluated her?
¿Cuál era la clase ASA de Maya cuando usted la evaluó inicialmente?
2.
How did you communicate with Beata and Maya? Did they know Spanish?
¿Cómo se comunicaba usted con Beata y con Maya? ¿Hablaban español?
No inglés.
No, in English.
Bad English maybe, but
Bad English maybe, but
How long after the procedure did you monitor Maya?
¿cuánto tiempo monitoreó usted a Maya después del procedimiento?
he sabido de ella durante todo este tiempo,
I've known of her during all this time,
pero los seguimientos se hacían aquí en Estados Unidos.
but the follow-up were done here in the US.
What symptoms of withdrawal, if any, do you monitor after the infusion?
¿Qué síntomas de abstinencia monitorea usted si hay alguno después de la infusión?
Cuando nosotros buscamos un síndrome de abstinencia,
When we search for withdrawal symptoms,
vemos por ansiedad,
we look for anxiety,
irritabilidad,
irritability,
lagrimeo,
tearing,
dolor abdominal,
abdominal pain,
diarrea,
diarrhea,
movimientos anormales.
abnormal movements.
Todos esos son los síntomas y signos frecuentes de un síndrome de abstinencia.
All these are symptoms and frequent signs of a withdrawal syndrome.
Did Maya experience any side effects from the ketamine coma?
Maya experimentó algún efecto secundario del coma por ketamina.
Probablemente tuvo algo de confusión mental en las primeras 24, 36, 48 horas.
She probably had some mental confusion during the first 24, 36, 48 hours,
Pero lo recuperó pronto.
but she recovered soon.
In the photo of Maya in the wheelchair, was that a seat belt to hold Maya in the wheelchair or a gait belt used for transfers? Or was it being used for both?
En la foto de Maya en la silla de ruedas, la faja, el cinturón, ¿era un cinturón de seguridad para la silla o un cinturón para transportarla? O ambos.
Muy seguramente era un
Any question whether one of these jurors is in medicine? Like any question whether one of the jurors is in medicine or has medical training or experience? Or past experience with law enforcement based on questions from yesterday? I mean, these are impressive. These questions are impressive. Gait belt is essentially, I think during transfer, they want to keep them from falling out it's not to keep them in the chair. It's to keep them from falling out while they're doing a transfer. It's like a guardrail on a bed. That's the concept.
cinturón para la silla.
Most likely it was a seat belt for the wheelchair.
Uno de lo que más tememos cuando un paciente tiene un CRPS
One of the things we fear the most on a patient with CRPS
es que tengan una relesión o una lesión,
is for them to have a re-injury or an injury,
porque eso va a exacerbar otra vez su problema.
because that is going to exacerbate again their problem.
Y controlar eso es difícil.
And controlling that is difficult.
Next question. How do you establish whether the previous diagnosis is a narrative or a legitimate diagnosis?
Can you read that again for the interpreter?
How do you establish whether the previous diagnosis is a narrative or a legitimate diagnosis?
¿Cómo establece usted si el diagnóstico previo es una narrativa o un diagnóstico legítimo?
Porque para nosotros saber que el paciente tiene CRPS necesitamos ver los signos y síntomas que hayan tenido en el pasado y en el presente.
For us to know that a patient has CRPS, we need to see the symptoms and signs the patient has had in the past and in the present,
Y cumplir con los criterios para CRPS.
and has to comply with the criteria for CRPS.
CRPS is a permanent condition. After treatment with a ketamine coma, what is the longest length of time a patient has experienced before relapse?
This question was good. This is a good question. The follow-up one is even better. They're good questions. It doesn't really mean they're good for the plaintiff or the defendant. They're good questions. I think that the answer to this, it might favor the defense And it's not this question, it's the next one. So I thought this was a good question. This jury's paying really close attention.
El CRPS es un padecimiento permanente. Después de un tratamiento coma por ketamina, ¿cuánto es el mayor tiempo que un paciente ha pasado antes de una recaída?
Tengo conocimiento de varios pacientes que han estado en el estudio
It is my knowledge of several patients that have been in the study
que han tenido relapso a la fecha.
that,
Que han estado sin síntomas hasta la fecha.
that have been out of symptoms to the date.
What,
To date.
what is the shortest length of time until a relapse?
¿Cuál es el tiempo más corto en que
This
haya
one.
ocurrido una recaída?
Al grado de llegar como estaban antes del procedimiento.
To the degree of being how they were before the procedure?
The question asks, what is the shortest length of time since the medical or the ketamine coma until there's a relapse?
La pregunta es, ¿cuál es el menor tiempo en que haya ocurrido una recaída después de un coma por ketamina?
Quiero decir 3 meses.
I'd like to say 3 months.
With CRPS, can a lesion form from a minor abrasion?
Con CRPS puede
That 3-month period that he testified to, that would place Maya on the lowest end, because from the testimony we know that she received the ketamine coma in the summer and she was admitted to JHACH on October 10th. So if you're talking about 3 months being the shortest period of time within which someone would have a relapse or a retriggering event, this puts her on the very short end. And I don't know if that helps the plaintiff or the defendant, but it popped up in my head and it made me think that the jury is very, very keen on timeline.
puede formarse una lesión de una abrasión menor.
Sí, definitivo.
Yes, definitely.
Puedo dar un ejemplo.
I can give you an example.
Hace 10, 15 días tuve una paciente que tiene CRPS
Just a few days ago, 10, 15 days ago, I had a patient that has CRPS,
y íbamos a hacer un procedimiento
and we were going to do a procedure,
y una enfermera le pidió que le mostrara su mano
and a nurse asked her to show her hand
porque no le permitían meter un cortamuñas.
because she was not allowed to bring a nail clipper into the OR, the operating room.
Entonces, cuando ella se descubrió su mano,
And I'm being corrected by the chat. If I'm wrong on this, that's my poor recollection of the testimony. If I'm wrong on that, I remembered that there was testimony about maybe it was one of the boosters, maybe it was a ketamine infusion in the summer months. It might have been one of the boosters. I'm doubting my own recollection of the testimony. There was one over the holidays, but why do I feel like there was testimony about the trip to Mexico in the summer? Either way, we're going to have to listen to the recap of the testimony in closing. I'll be curious about that. I might have forgotten. That's my bad. It's my bad. It's my fault.
So when she uncovered her hand,
ella tomó a la paciente de la muñeca.
she held the patient by the wrist.
Para el día siguiente tenía un dolor excruciante, un dolor excruciating,
By the following pain, she was in excruciating pain,
y le aparecieron lesiones
and she had injuries. And injuries appeared
con solamente tocar.
from just touching.
Can a cut or abrasion turn into a lesion?
¿Puede una cortada o una abrasión convertirse en una lesión?
Es una lesión, o sea, una cortada es una lesión.
It is a lesion. A cut is a lesion.
Y difícil, o sea, una úlcera o lesión por CRPS
And difficult, but I mean, an ulcer or lesion from CRPS,
a veces es difícil. Es difícil para mí decir que una lesión se va a convertir en una lesión de úlcera de CRPS.
I mean, it's difficult for me to say that a lesion is going to turn into an ulcer or a lesion from CRPS. That may be.
Porque estas lesiones salen espontáneas.
Because these lesions appear spontaneously.
During your diagnosis of Maya, what symptoms from the constellation of CRPS issues did you document and observe?
Durante su diagnóstico de Maya, ¿qué síntomas de la constelación CRPS observó usted y documentó?
Ella tenía un dolor intenso, no relacionado a ninguna lesión.
She had intense pain, not related to any lesion.
Perdón, no relacionado con ningún otro padecimiento.
I'm sorry, not related to any other condition.
Pero ella tenía alodinia,
But she had allodynia,
hiperestesia,
hyperesthesia,
Ella tenía cambios de temperatura,
She had changes to temperature.
ella tenía cambios de coloración,
She had changes of coloration.
ella tenía la distonia,
She had dystonia.
y lo único que no encontré fue cambios en la sudoración
And the only thing I did not find was changes in her sweating
o crecimiento de vello o uñas,
or growth of hair or nails.
pero el resto lo tenía
But the remaining others she did have,
ya sea al momento de la evaluación
either at the time of evaluation
o justo en el pasado.
or just prior.
In pain management situations, what does withdrawal manifest as in intelligent patients?
En situaciones de gestión del dolor que se manifiesta como abstinencia.
Regardless of how good these questions are, I do have to fast forward. I have to get to our next witness because we're not going to get to anything else. If you guys want to, I'd encourage you to go back and listen to the rest of those jury questions. He does a good job. He stands up to them. They're really good questions. There's a lot of them. And the judge takes his time making sure the questions are answered. And this witness does a good job of looking at the jury when he answers the questions. From some very important points I took away. He's never lost a patient in any of his studies with any of this. He hasn't seen any patients lost during any of the studies with this particular procedure. While it's outside the box, it's not. The ketamine in Mexico is still regulated, so it's still something that he has to get approval to at least administer. And that based on his summary, that Maya was very clearly had CRPS based on his criterion, his objective or his observations of her, and that he thought the ketamine infusion was helpful and worked. I don't think defense did too much to damage him. I'm trying to remember. I don't think they did. They tried. I don't think they did. So I thought he was very effective. He was very effective, even though you had to go through translation. So, yeah. Let's go ahead and fast forward to our next little bit here, because I want to make sure that we're getting things that we need to get through. Next up is the afternoon stream. Let me pull this down and pull up the afternoon stream. Afternoon stream, where are you? Where are you? There you are. I found you. I found the link to my timestamp too. All right. So we have motions, arguments. And let me see if we've got any things catching up. Make sure I've got these things caught. 8 months. It seems like just yesterday. Glad to see you, R. Bauer. You remember and still have been. Thank you for being a member. Glad to see you here. Matt Bond, my daughter was put into a induced coma for 2 weeks when she had group A streptococcus flesh-eating virus. It took half her calf muscle. Medically induced comas aren't as rare as a lot of people were thinking. And if there's someone on that jury who has experience in the medical field, people were asking, why would someone be on the jury why would they let them on the jury? I think the defense might want them there because the defense might think that they might be judging the decisions of the Kowalskis as a medical practitioner. And the plaintiffs might want them on there because they think they might be judging the decisions of the medical practitioners for Hopkins. So I don't know that either would object for cause based on that, because I think they both might think they could persuade them one way or the other. But yeah, medically induced comas, that issue came up, and I think the jury is well attuned to what is or is not appropriate. Kim Pascucci question: do you know what the orders were by the court? The judge is going to lay that out in instruction. The orders are orders that were dependency court orders. They were orders that governed how Maya was to be sheltered, who was allowed to see her, who was allowed to talk to her, who was allowed to access her, what the conditions of her access were. Those are the dependency orders. The judge has to walk through and give very clear instructions to the jury of what the orders said. And it's a tough instruction. Leader Randolph, Rob, thank you. Interesting comment from a European doctor who spoke on the case. Medicine only advances when people are willing to try new things. It's an interesting comment. It's interesting observation. That's how a lot of science advances. OB Nurse Chelsea, this is like the 5th time we've heard this 50%. Where did it come from? It has to come from somewhere. I doubt medical professionals would make it up in court. I don't know where it comes from. I really wish someone would tell me. I really wish someone would tell me. Rihanna, thank you. As a medical interpreter, I'm nerding out on this. Heather, good to see you, my friend. Rob, what if a juror speaks Spanish and knows the translation is wrong? They tell the other jurors why they're deliberating. No, that's a very strict instruction. The judge says that you cannot tell anybody else that you believe it was misinterpreted. And even if you think it was misinterpreted, you have to take the words that were translated as what the translator said they were. Blessed in Texas, been with you since your first lumber video, being on disability. I'm hoping for you get some membership. Thank you, Law and Lumber and moderators. Thanks to the mods on all platforms and all forums. Thank you guys for being here. It makes handling difficult cases like this a lot easier on me to manage a chat like this. Fairy Godmother later he said to the judge, as you know, I have personal issue when talking about the calendar. Oh, that's as to Anderson. Okay. Like I said, heart goes out. OB Nurse Chelsea, when he refills the water cup, it's so funny and endearing. It is. It was a funny moment. I wish I had caught that. I didn't, and I've got to keep moving on. Allie B from Tennessee, love this community, such a kind group. Thank you, Allie B. M2HMGHB. As a deputy son, the routine was to call dispatch, who would relay to a clerk, who would send it to the judge of the room, who would give it to my dad. Oh, information. Dispatch. Okay. All right. So I don't know that we're going to get an update. I don't know that we deserve an update. We don't deserve an update on his personal life. We don't deserve an update on his personal life. When I was making that comment, it was because that was brought to my attention several times, and I felt like if I didn't address it, I'd see a million questions. So what I wanted to do with that was to kind of emphasize that these attorneys, they have normal lives, they have families, they have things that are occurring outside the courtroom that they can't attend to while they're in court. So I was just asking for people to show a little grace. That was kind of the purpose of that. And I appreciate the people in the chat who have done just that. And I figured the best way of asking them to show a little grace was to share a little bit of my own story. So I think let's respect his privacy. If he wants to come out and talk about it, he can do that. I'm not gonna invade it. So let's go ahead and share the screen. Can we do the things that we need to do? No, we can't. Apparently we can't. Can we? Can we do this? We can do this. Do we not do this? We do. No, we don't. I did. We do know how to do this. Let's see here. Share screen, share audio. Okay. Now, let me replace the little sticker to show you where we are. No longer Dr. Cantu. Now we're in motions and argument. So let's go ahead and listen to how the afternoon is going to play out. No.
Before Dr. Henschke testifies, most of her records that talk about relapse deal with litigation-related stress. That's clearly not a compensable action in this. And just so I'm not jumping out of my seat, I was wondering from the plaintiffs if they're going to be arguing that, or proffering testimony to Dr. Henschke that Maya is having relapses because of the stress of the litigation, which would not be a material issue in this case or compensable.
It is. I am offering it for the purposes of demonstrating that she has relapses. The defense has contended that she was just bright, sunshiny, and smiling through the entire period of time after she left their hospital. This demonstrates and proves that the child did have a relapse. The only thing we can look for exactly what it says. It says there was a deposition. That's all. It doesn't say anything else about it.
Can I see what we're talking about?
Sure.
Yes, sir.
Have we been providing the redacted copies yet? We still don't have a redacted copy.
This is the unredacted copy, Your Honor.
There's a whole bunch of handwritten notes on this, so I'm not.
I think it's hers.
Well,
Have you shown this to Mr. Shapiro before I start looking at it? Something that has a whole bunch of handwritten.
There's no handwritten notes on her records.
I just did. Let me look.
Perhaps we can just put it in one of the records. It's a trial exhibit
Correct.
2011-16.
Yeah, here's the records. This is
2011-16.
Correct, Your Honor.
May I see it, please?
These are redacted around the
And
Yeah, I'll focus you in, Your Honor.
help me out.
Yeah, so the third paragraph, patient states the trial against the hospital got pushed back and school started a month or two ago. She's struggling to focus this year. Midway through the paragraph, due to the trial being pushed back so many times, she does not have faith things will happen on time. All four notes talk about her stress level being related to litigation. And I'm honestly looking for guidance how to handle this.
So
What I would ask, this is what I would ask from the plaintiff in the court, that while they can certainly ask Dr. Henschke if Maya experiencing stress has led to what she may describe as a relapse of the symptoms, that's fine, I think that's the way we can cover this. But to go into the fact that this was caused by the stress of this litigation, by defense counsel, by any things of that nature would not just be prejudicial, but it would also be, it would not be compensable.
I do not intend to make any accusations as against counsel or the litigation. It is in her file as the reason, truthfully, that she had one of the reasons she had a relapse, and the jury would be entitled to. There's nothing particularly damaging here. It's simply that this has become a stressful situation for her. Part of our case is to demonstrate a stressful situation. It's not part of the compensation. Again, what we're trying to establish here, Judge, is that she was not fine, and that her CRPS is activated by these types of situations, by stressful situations. They can cross all they want, and I don't intend to come up and ask her a ton about, now, were they need to use the deposition? No. But in her records, it should remain truthful as to the reason. I will save the arguments about what actually happened.
I have the
what
court
has
volume
actually
bumped
gone on
up
in this litigation for another
full
time.
blare.
But for these purposes here, this is simply the truth. And it's not being derogatory in any way to the defense or to Johns Hopkins.
Just very, very brief response. The problem with this is it's not compensable, and I don't know how to address this without either redacting most of these records or having the court inform the jury that any stress related to the litigation process is not something the jury can award damages for.
Why are we hearing this at this time? They've had at least, when was the first time we sent the exhibit list to them?
And more importantly, we went through this morning on this exhibit, and we've been in the process of redacting, going back and forth in this crawls for the past 4.5 hours. We finally got the exhibit correct with the redactions that were discussed this morning. Now we come in here and we're blindsided with new redactions that are requested.
They waived them by any stretch of imagination.
We just had one person talk to them. And then
I'm not asking for additional redactions. I would have been happy to bring this up at 9 in the morning, but we had the jury waiting. I thought it'd be better to do this.
All right. Everybody's tired. Everyone's pissed off. So, precursor. Everyone's tired. Everyone's pissed. And the judge is like, children, behave. Mr. Shapiro is making a good point here. The point that he's making in this argument is that you can't, and this is a pretty important clarification because people have been asking me this particular question quite a bit. And one of it was, let me see. The question is why are they not allowed to use the stress of trial? Why are they not allowed to use the fact that Hopkins made her file a lawsuit against her and that caused her stress? And why can't they compensate her for that? The answer is because that's a judge question. Whether someone was litigating unfairly, whether someone was violating discovery rules or playing games with pleadings or using tactics that were untoward in the legal system or legal process, that's the judge's call to issue sanctions. The judge can sanction the attorneys to remedy that problem, or sanctions the attorneys or the parties to remedy that problem. In this particular instance, they can't bring it up to plead damages because the damages must stem from the underlying action the hospital took, the underlying action, that first cause. Those are the damages. Those are the injuries that she suffered. So when Mr. Shapiro is saying it's not compensable, he's correct. The jury is not allowed to factor into their compensation to the extent they side for the plaintiff. They're not allowed to factor into that compensation the cost of trial. They're not allowed to factor into the compensation motions practice. They're not allowed to factor into compensation the mental anguish of being in the trial. They're not allowed to do that. The judge can weigh that when the judge is determining punitive damages or sanctions, but the jury can't do that because that goes outside the bounds of what's required to compensate the plaintiff for the injury they sustained by the hospital based on the facts that were alleged in the complaint. It's a technical nuance, but Mr. Shapiro has the right of this argument. And I get Mr. Anderson's frustration because he doesn't intend to argue this. He kind of does. Let's be honest. He does. But Mr. Shapiro is correct in this argument, and the judge sides with him. I'm not surprised by it. And I don't think Mr. Anderson is either. When he makes his head bowed here, he's kind of conceding that that this is a point that he's not intending to argue this. So it was interesting.
All of that being noted, it's just a matter of the argument that the relapses, if they're related to litigation-related stress, were not compensable. And I still do not have a copy of the redacted records to proceed on this witness.
You're checking this.
As of the moment, he does not have it.
Like I just said, Ms. Crawls and I just worked this out in hallway over the lunch break.
My trial technologist still does not have a copy of the redactions. Anyway,
Are you asking me for a ruling?
I am asking you for a ruling, Your Honor. I apologize for being vague. We would like.
Again, judge is like, children, Stop. Stop, children. Behave. Behave.
A ruling that the plaintiff cannot ask this witness on the witness stand that what the cause of her stress is. And since these records are going to come into evidence, we would like the jury to be informed, and we'll draft appropriate instruction for your consideration at the appropriate time. Since this is going in evidence, that litigation-related stress would not be a compensable damage to the plaintiff. But I won't ask about the abstract. We can draft something to that effect for your consideration.
And we vehemently oppose that, and we should not have, this is something, I don't believe that's true, we haven't had a chance to research it. But if there is something about, because you mentioned litigation, that it somehow becomes compensable, then that can be handled with a jury instruction.
Here's my view.
Thank you.
I do not want there to be discussion about the trial being moved back, because I don't want to open up the issue of that amongst the jury as to what happened. Was it somebody one side's fault or the other side's fault? That's clearly not something that is in the purview of the jury. I don't see, however, how you can legitimately keep out the concept of, in a general sense, that litigation is stressful, and that Maya, obviously going through litigation, has stress associated with it. I don't see how you can not say that. Now, I'll consider the instruction about, members of the jury, you heard that, but understand that that piece is not compensable. I think that's the way to deal with it. But I really don't want to get into discussions, questions, Mr. Anderson, about the reason why the trial got delayed last year. I just put that out there.
That's not my intent in any way. I simply want to there has to be some reason why she had this relapse, and that's unfortunately was the reason. So my intention is not to do that. So the court having ruled, I would like to proffer the testimony of Jack.
Okay, let me explain. People who have criticized this judge ultimately sides with the plaintiff and says, plaintiff, I don't know how I can keep this out. The jury is obviously going to consider the fact that she's able to have relapses and that the trial might cause that. Of course, they're going to consider that, but I think they should be instructed that they shouldn't be considering that when calculating damages. He sides with the plaintiff, but he says it's worth clarifying. And he looks back at the plaintiff and says, you're not going into this, are you? And he says, no, I'm not going to go into that. He might have tried, but no, I'm not going to go into that. It was people who have criticized this judge. This judge is fair. Now, people might have opinions based on what we're going to hear next. I will explain that too when it comes up.
Henschke regarding the sexual abuse.
We do that after the jury goes home,
Yes.
because I've got a jury waiting.
All right, Your Honor. I'll await that. Okay.
We still need the exhibits from your technologies right now.
Mr. Reyes, have you finished whatever redactions that were?
Appears to about to get punched in the face, man. If someone kept bothering me like that, we still need the exhibits.
Is that the one from this morning?
It is, with the redactions that were corrected over the last few hours.
Be happy to give it. You can give it to the clerk. Thank you.
I was just looking at my notes, Judge. Part of my introduction is how she got involved in this. And in it, she will explain that she was contacted to be
This is gonna
a
piss the
safe
judge
harbor
off.
and why and how she was contacted and what the direction was to her. And that is obviously very relevant, how she came involved in this litigation. And it certainly is the truth. So I will not emphasize it, but I do want to be able to say that she was retained in connection with this litigation. And the purpose was for her to be someone that Maya could talk to.
Stop on that issue.
Warning. Judge is pissed. Judge is pissed. He has reason to be pissed. Both attorneys at the defense jumped up. Plaintiff was like, I want to clarify something that you didn't let me clarify.
You suggested that. I never said that was allowable. You seem to feel that a plaintiff is allowed to have doctors without the records being turned over when the plaintiff is making a claim. I never agreed to that. That's something that you wanted, but I never said so. I don't think you should try to make those statements or elicit that information from this doctor, because that was never agreed to by the court.
I'm unsure. I believe, Judge, the way that it went down was we presented the court with the fact that Maya Kowalski had no one to talk to, because every single time she ever had talked to anyone, the defense would subpoena the records and then depose them. And so we proposed to the court and to defense counsel that this child have a safe haven, someone she could talk to, and we pledged in return we would not use her records and we would not use her testimony if only Maya could have some place to talk. And then as time went on, the defense moved and wanted to do a subpoena ducis tecum, and that was allowed over objection. And then the defense wanted to take a deposition, which was allowed over objection. Then once they'd already deposed the doctor, and once they made it clear that they intended to use the doctor's testimony, then I put the doctor on our list because I had to counter that.
And again, I did not make the rules with respect to what is and what is not discoverable relative to when a plaintiff makes an affirmative claim. Those have been well known. You knew them. And what you were asking was a legal impossibility. I dealt with that months and months and months ago. And I said no. And I'm saying no again. I don't know why we have to keep talking about the same issue over and over again.
I need
I'm
instructions.
done.
I need
That
instructions.
issue. Please don't go into that issue with this witness. Now, may I bring in the jury?
Yeah, yes, Judge. I need to inform her not to, what she can and cannot say for a moment.
If the plaintiff wants to withdraw her, we're not going to object.
No, we're not withdrawing her.
Let me explain. No, that's too much. Let me sum up. Okay. To summarize what we just heard, here's what happens when a plaintiff places at issue, for example, intentional infliction of emotional distress. They have placed their emotional condition at issue. When I file a claim that says you have engaged in an action that inflicted emotional distress upon me, my emotional condition, my psychiatric condition, my psychological condition, I have put that at issue. I'm trying to recover money from you. I have said, this is the thing the court has to consider, my condition now, which means the defense has every single right to discover information from my treating psychiatrist, therapist, counselor, etc. You guys might think that's wrong. I understand that. It might feel difficult to process, but the decision of whether to bring a claim or not rests with the plaintiff. And I have known plaintiffs who have willfully ditched claims entirely because they don't want that issue brought up. For example, in divorce cases, when I'm doing divorce custody cases, the parent's physical, mental, and emotional condition is an issue the court must consider, which means that I get access to psychiatric notes. Now I get access to those notes, and they're released under a condition of seal. Like sometimes there's attorney's eyes only. Sometimes there's not to be republished. Sometimes there's destroy at the end of trial. I have any number of conditions placed on me when I have these notes in my possession, but I get the notes because I get to see what's going on. I get to see whether that person takes the stand and lies about what they're telling their psychological condition. I get to verify that. Because the jury, they're asking the jury to compensate them for the damage to their emotional condition. What the plaintiffs tried to do here was the plaintiffs basically said, Maya is undergoing ongoing treatment. We want a therapist to be immune from discovery. We want her therapist to be immune from discovery. We're not going to use them. You can't get them. If it doesn't ring true to you, the fundamental unfairness of that to the defense, if you are seeking compensation for the harm to your mental condition and they can't see what the mental condition is at trial, you can't do that. So the judge says, this is a legal impossibility. I could not have done this. And the fact that you were going to try to say this to the jury, that Maya never intended that you were hired because Maya thought you would be a safe place to go to and you wouldn't be discoverable. I mean, that is not fair. It's not fair. Dr. Barry, clinical note or report is often more powerful than in-court testimony. You need to see it. They get to see the notes. They get to see the notes. Amber Heard, Johnny Depp, they exchanged the therapy notes were there. They had them. I don't care if the parties don't see them, they get them. They just do. They get them. So it's a complicated issue. And I know that people have very strong opinions about it, but what the plaintiff tried to do here was that was a little bit, I mean, that was audacity, kind of like, so judge, we totally want to completely disregard that you told us we couldn't do this, but we want to bring her out and say that she was brought on because we thought that she would be a safe haven for Maya. The judge's like, no, you're not going to lead the jury down that impression. No. And then Shapiro, please give me a little bit of a prick. He really can be a little bit of a prick. Shapiro goes, if they want to withdraw this witness, we're fine with that. Do you know how much money they probably, you know how much this witness probably prepped for this? You know how much they, oh, the little side jab, man. The little side jab. Anderson was having none of it. Like that's like Shapiro at the end of today, Shapiro was aiming for a punch in the face. He was going, someone's going to hit me today. He kind of deserved it too. He was just throwing jabs at the attorneys. It's one of those where when you're a lawyer in court, and don't think we don't think about it. Don't think we don't think about it. We do. Like I would love to take this binder and hurl it across this courtroom at your face right now. Not going to do it. Not going to do it. I'm going to stare daggers, be really upset, regain composure. I'm going to put my mask back on. Oh my gosh, that last remark, that last little jab, that was a lot, man. That was good on Anderson for not jumping at that, for saying we're not doing that. He just said we're not doing that. So good on Anderson for not falling for that bait, because that was a trap. That was a trap. So with all of that in mind, why don't we listen to our good doctor, 1906. And we're only going to listen to a little bit of her testimony. It's not a whole lot. We'll go again to the jury questions because, like I said, those to me are the most important thing. I like those. So.
Please state your name for the record.
Dr. Jacqueline Henschke.
And what is your specialty profession?
I am an adult and child psychiatrist.
And have you been asked here to offer opinions, having examined and treated Maya Kowalski during the period of 2021 and 2022?
2022 to 2023, yes.
Oh, 23, excuse me. Can you give the jury a little bit of detail about your background, training, and experience, beginning with your undergraduate degree?
Yeah, I was born and raised in Washington, D.C. And
You
went
have a
to...
very soft voice. You might want to talk to them.
I do. I was born and raised in Washington, D.C. Went to Georgetown University for my undergraduate degree. Spent a little time in New York bartending, and then decided to go to medical school at Tulane University in New Orleans. I decided initially to go into pediatrics. I did my intern year, which is your first year of your residency, at Miami Children's Hospital in pediatrics. And then I decided psychiatry was a little more my thing. So I transferred to George Washington University and completed my adult psychiatry residency. And after that, went to Stanford in Palo Alto, California, and completed my child psychiatry fellowship.
And then since that time, have you been, is that where you did your residency then? Was it Stanford? Or?
Stanford was my fellowship for child psychiatry, and then the residency for adult was at George Washington University. You have to complete your adult training first, and then you do your child psychiatry training.
And so the jury understands, are you board certified?
I'm actually double board certified. So I have to be board certified in adult psychiatry, and then I had to do all the exams to get board certified in child psychiatry.
Following the completion of your schooling, can you tell the jury about where you started your practice?
Yeah. So after I completed my fellowship at Stanford, I went on to return to New Orleans post-Katrina. It was in 2009. And I was a professor there, and an associate professor. And then I was hired to head the consult liaison team, which is just a fancy way of saying I was a psychiatrist that was in the hospital that all of the primary teams would call if there was an issue. If a child was depressed because they were receiving chemotherapy, or the family was distressed, then I would go see them.
Before we continue on, can you tell the jury that when you went back to Tulane post-Katrina, did you see and treat victims of Katrina?
Yes.
And tell the jury primarily what the diagnoses were for those victims that had been through that.
Most of the primary diagnoses were post-traumatic stress disorder. In general, when you're a child psychiatrist, you tend to see a lot of trauma, especially if you're seeing children 6 and up.
Okay. And so how long have you been in private practice?
How
long have you been practicing child and adult psychiatrist?
I've been practicing since 2005.
And the difference between a psychologist and a psychiatrist is the psychologist has a PhD and you have a medical doctor degree.
Correct.
So you can prescribe medications and so forth.
Yes, but I'm also trained in therapy in addition to prescribing medications.
All right. Can you tell the jury then, let's continue on with your experience then in hospital settings around the country?
So at Tulane, was head of the consult liaison service. So that meant I worked primarily at Tulane Hospital. When I was at Stanford doing my training, I of course worked at the Children's Hospital at Stanford. And when I was at Miami Children's, that was a full children's hospital as well. And then I've worked in full psychiatric hospitals that are only seeing psychiatric patients.
And so how long have you worked in and about hospitals as opposed to a private practice?
I would say in hospitals throughout my whole career. So there are times where I have done outpatient, but at the same time, I will cover a hospital on the weekend to do the consults. So throughout my whole career, since 2005, I've been working in hospital settings.
And where do you live now? And then where do you practice?
I currently live in St. John's, Florida, between Jacksonville and St. Augustine. And right now I'm doing full-time telemedicine to a psychiatric hospital in Colorado. I'm licensed in Colorado and Florida.
And how does that work out? Is this telemedicine? Or?
Yes, it's full-time telemedicine. I see the kids over telemedicine, and sometimes I do see adults as well.
How many cases of PTSD and depression can you estimate that you have seen and or treated in the course of your career so far?
I would say thousands. Cases of PTSD and depression, ADHD, all of the pretty common diagnoses, schizophrenia, bipolar disorder, eating disorders.
Well, what I'd like you to do is explain a little bit about the history of PTSD and to differentiate it from other psychological psychiatric problems. So
PTSD has been known as a phenomenon since at least the Civil War. It's been documented. At that time, it was called soldier's heart. And then in World War I, it was called shell shock for soldiers returning home. World War II, battle fatigue was also called war neurosis. But in 1980 is when PTSD officially entered our diagnostic and statistical manual. That's the manual we use to make diagnoses. And in 1980, there was a big shift from just making diagnosis based on observations to using studies and evidence-based medicine to make those diagnoses. So PTSD entered at that time. And we could see from the reason it entered, we could see slews of, large numbers of veterans returning from Vietnam with PTSD, really affecting the course of their lives. It wasn't just affecting them as they were in the moment of the trauma, but even lasted long after the trauma had occurred.
My microphone was muted. I had 2 comments. Oh my gosh, this is remarkable. Of course it is. Second time today. One, she's remarkably well credentialed. 2, the notes were entered, the psychiatric notes, they were entered, but they were redacted. They were parsing through what redactions were appropriate, and they did have objections and rulings on that. So it's not like every single element of the notes were in there, but they were redacted. So I don't know. It's not like the jury's going to see all of them. They're in evidence. It depends on the jury can access them if they want. We shall see. Yeah, Carol Greer, I need something to notify me when I'm on mute. I try to mute myself so you guys don't hear me. If I cough or sneeze, I want you to hear the testimony, because especially when the court's quiet, which is tough.
Is PTSD a dangerous psychological disorder or psychiatric disorder in the sense of harm to the patient?
Yeah, it puts you at risk for many complications throughout your life.
So were some of those victims of Katrina, were they children with PTSD?
Yes.
And what were some of the recurring factors and things that you noted there?
You mean the symptoms that they would present with?
Yes, rudderless and
depression, anxiety, chronic medical conditions would exacerbate their PTSD as well. School absences, school failures, not being able to kind of continue on the natural course where you would expect a child to. It was also stressful for the family to manage overall.
Now, you were referred at one point over to Maya Kowalski to care and treat for her.
Yes.
And I believe that came about when you and I met at a social function for our children, and I found out you were a pediatric psychiatrist and asked if you would help. Do you have your notes there before you so you can tell the jury the first time you saw Maya?
I do. The first time I saw her was October 27th, 2022.
And for the record, Judge, these are in a trial exhibit 2011-016 is the first one. The last page, I think, is 041. All right, so how did Maya Kowalski present?
So she initially came to me because she was having a resurgence of not doing so well. She was having more flares of her symptoms of complex regional pain syndrome. And she was also reporting symptoms of depression, PTSD, anxiety, and a lot of problems with focus.
Now, to the best of your knowledge, had she been diagnosed with PTSD or depression prior to October 7th, 2016?
Not to my knowledge. So I only met with Maya and spoke with her father. I didn't review any of her previous reports.
All right, and the date of this first visit was again?
October 27th, 2022.
All right. And what, if anything, was significant in the history of Maya in terms of events in her life that you focused on in determining a probable or working diagnosis and treatment?
So, what she reported to me, which was relevant, and I can read directly from my notes. She said that with her complex regional pain syndrome, she felt alone and misunderstood. But she said after she was hospitalized at Johns Hopkins and her mother's suicide, she said, quote, it was a different kind of sadness. And so she was really struggling with.
How had she been doing up to the point that she saw you? Was she functional, non-functional?
She was somewhat functional, but not what I would consider to the best of her potential. She was doing online schooling. She was avoiding going to any doctor visits at all because she was very afraid of what would happen to her. And she reported significant symptoms of PTSD associated with physicians, hospitals, going to St. Petersburg. Just driving over the bridge made her feel anxious. She reported flashbacks about the hospitalization and general worries about her safety and her family's safety. And she also had withdrawn from activities that she had previously enjoyed doing prior to the hospitalization.
And did those include piano?
All right, we're going to fast forward a bit. So I like to give you guys the intro of who the witness is, what the crux of their testimony is, and then I'll kind of summarize. So she continues to testify about Maya and her well-being, that she's going to suffer from this forever, that in her opinion, the hospital caused it, that it's PTSD and depression. Defense counsel tries to minimize the depression, saying, isn't there kind of a lot of depression? She was a good witness. She was good. She wasn't the strongest, but there were questions by the jury, and one of them was rather significant. And do you guys remember what we talked about when this witness started? What Mr. Anderson really wanted to get in? Well, the question comes up, and they have a long sidebar where they actually excuse the jury so the judge can ask the witness what question or how she would answer the question to make sure that they're not going into that realm. And then the judge says, if you could, when I bring the jury back in, if you could just answer the question exactly like that. Exactly like that. So I need to fast forward to 154:44. Let's go with here.
Now, the next question, what percentage of females 18 to 25 are diagnosed with depression or generalized anxiety?
Oh, dang it. It wasn't this question. But the judge brings the jury back in. The last question that he asks, he wants her to answer the same way.
If we're looking in the US, what percentage? Or what percentage of my
It
patients?
says what percentage of females 18 to 25? The question doesn't say whether in the US or in your practice. So why don't you give us the US if you know it?
I would just be ballparking it in the US. I haven't looked at those statistics for a while. I would probably say maybe 60 to 70%. I would have to double check that though.
Okay. Though Maya's situation is tragic and unique, the diagnosis is no longer uncommon, and that's the CRPS, the depression diagnosis. Is that correct?
Oh, could you repeat that one more time, please?
Though Maya's situation is tragic and unique, the diagnosis is no longer uncommon.
Of depression?
And I think it's depression and generalized anxiety is what the question was asking.
No, I wouldn't. Yes, they're no longer uncommon.
And how common is adult ADHD versus pediatric ADHD?
Oh, that one's a harder question to answer. We don't have a lot of studies comparing both
Hi.
of those. So it has to do with also kind of social influences too. So there are a lot of
ADHD.
adults that have went undiagnosed as children. So it depends on what generation we're looking at as well, like what percentage between the two. So it would just depend on the age.
Okay, the next question, if your recommendation for Maya's treatment is weekly therapy sessions due to her intense childhood trauma, why were your sessions with Maya only held monthly?
Also a good question. So there are not a lot of child psychiatrists in the country. And the bulk of my time is taken up doing medication management. So the way that we do the model now, as opposed to many, many years ago, is that the psychiatrist will do the medication management portion, and we'll have a licensed therapist, that can be a psychologist, a social worker, a licensed mental health counselor, to do the therapy portion. So I was seeing her for the medication management piece and did encourage her to start therapy. She was very hesitant to start therapy.
And the last question, why hasn't Maya been seen by you since January 25, 2023?
Once she found out my records might be subpoenaed, she stopped seeing me.
Mr. Anderson, any further questions?
The The generalized anxiety and depression that
They don't really go very much, but it was that point. It was that point. So the implication is there, but there wasn't further commentary on it. So the jury is allowed to draw their inferences as to, and you know, the jury probably had the question like, why? And they did. They asked the question. They said, why was the last time you saw her way back then? And it was basically because once she found out the defense was going to subpoena my records, she stopped seeing me. It's pretty sad, but it also raises a question as to why. If you're pro defense, if you're pro hospital, you're going, why? If you're pro plaintiff, then you're going, that makes sense, and that's tough. Zach, this is a good question. Is that good or bad for Maya's side? It depends on how the juror that was asking that question was coming at the question. If I'm coming at the question from a pro hospital standpoint or a skeptical standpoint of Maya, and I'm going, you just didn't want them to figure it out. You didn't want them to see something that would have made your claim less strong. That's how if a juror was thinking skeptically of Maya's claim, they would think of it that way. But if the juror was thinking favorably of Maya's claim, they'd be upset. They'd be pissed. They'd be thinking that, wow, the hospital deprived this girl of a therapist that she needed because she became too afraid based on her past interactions with doctors that she withdrew from this doctor. It really depends on how persuasive these attorneys have been. It really depends on how persuasive these attorneys have been. Because the rest of the doctor's report, reported of fear, like paralyzing fear of seeking medical treatment, like to the point where she would have like a fever and wouldn't go see the doctor. I don't know. It depends on how the jury is perceiving what's being said. And one juror could view it one way, another one could view it another. So it's kind of a challenge. And people are saying that, can I poll the jury, or can I poll you guys and see how you would respond to that question? I think I can do that. I have to end the existing poll right now. The existing poll was who you thought was the most impactful, with 1,325 votes in. 46% said Zimmermann, 34 Cantu, 18 I'm gonna Dr. H. We're gonna call her Dr. H. I'm not gonna butcher that name. The last question already stopped seeing good, helpful, or harmful to plaintiff / Maya. You guys can go ahead and answer that question while I catch up on some of the chats before we get out of here. Yes, there was a proffer that was at the end of the day about what she would have testified to had she been allowed to on the sexual assault. I'm not going through that. I don't have time. Let me just make sure I'm catching up on chats, and then I got to get out of here. I have court tomorrow in the morning. Not the same ungodly hours this morning, but I still have to get there. So, and this was what I started this a while back, Jules. At the end of the day, the truth came out anyways because the jury questions. It did. The jury was right there. The jury had reached that conclusion, period. They were there. So, Mary Coppola, thank you. Then why have her testify? She shouldn't be a witness. Speaking to the doctor? No, the doctor testified fine. She did well. She gave her opinion on the cause of the PTSD, and that being the hospital. M169, I love the Princess Bride quotes. Always spot on. Thank you very much. Matt Bond, damn no lawyer or someone to vent to privately. It's tough. It's a tough question. Jules O, the faster speed. Anderson's a slow talker, so speeding up makes him sound normal speed. He does talk kind of slow. Liddy Marsh, thank you. Gate belts can be facility policy. They can help staff life. They can help staff's lives when walking steady a patient. Can prevent injury to staff and a patient. Yep, that was a point that was made earlier. Apple Silver, what did Yoda say when he saw himself in 4K? HDMI. Oh my gosh. That was a good one. I needed that. XO BR1, BR1 XO. New to you, but my daughter's on med that's used for blood pressure that's being used on her to slow tumor growth. It's experimental, but it's working. If it's working, it's working. At some point in time, and the doctor made the point that you got to look at the quality of life, and it becomes a decision for the patient on how far and how aggressively they want to tackle this. So that's kind of one of the questions that's like an overarching theme to this particular case. Before I end that poll, I do want to thank the fact that there are a lot of you very, very, very generous in the chat tonight with gifted memberships. Ange Torres gifted memberships, Baby Gator with gifted memberships, Icosaplex gifted memberships, Musical Soup with gifted memberships, Dawn Burke with gifted memberships, Katrina Hetherington with gifted memberships, Jen with gifted memberships, and Lori Leanne with gifted memberships. I see a lot of new names in the chat, and I love having you all here. I really do. Someone was asking when I'm going to be doing my next members only live. If I'm doing the Kowalski recaps, I don't have time to do the members only lives. I will try to get back into the shop, show you guys what we're working on. We're making some cool stuff on the lathe. I made some glow in the dark stuff. It's a lot of fun. But I will get down there. I promise. I will. And I will find a break in this trial to do so. I will. Because I did want to kind of also highlight the fact that because of the generosity, people are saying, thank you for the gifted memberships. I want people to acknowledge that because of the generosity of the chat and the people that are gifting memberships and the people that voluntarily member or subscribe to the channel and become members, there's a difference, by the way. You can subscribe, no cost. Membership is if you want to support the channel, if you want behind the scenes access to the shop streams, that's the membership stuff. And also there's Trials of the Century that we do sometimes behind the scenes. So that's why a lot of the existing members will gift that because they want you guys to be able to see that stuff. And because of that generosity and the generosity of everyone else, I think the channel right now has over 2,000 channel members. It's really, really, really amazing. I never thought I'd be here. Never thought I'd be doing this. So I really very much appreciate all of the love and support that you guys give to the channel. The recaps are tough. They're a drag. They're difficult. But I think they're important because it's an important case. So thank you guys for being here. I very much appreciate it. Thanks for catching the recap and for all the comments and for engaging. Please leave a comment below. Oh, the poll question. Let's answer that. Let's see. Oh, 530 votes. 530 votes. 532 votes. And we've got 76% say helpful. 23% say harmful. Okay. That's about the divide I thought it would be. It's about the divide I thought it would be. So to those of you guys who tuned in, thank you very much for being here. There will not be a recap tomorrow night. There will not be. I have, like I said, I have court and I have a late afternoon meeting. I don't have time to catch all the testimony, so I can't recap tomorrow night. But I don't think there's no hearing. There's no trial on Friday. So I might be able to do a quick recap on Friday. And then next week, early next week, Maya Kowalski takes the stand. So that's where we are in this trial. All of you guys have a wonderful evening. For those in the replay crew, thank you. Please leave a comment below on whether you like this coverage, don't like this coverage, whether you want to see more or less of the commentary. I very much appreciate it. And don't forget to hit the like button on the way out. Good night, guys. Thanks for being here.